There is a federal law that makes it a crime for public officials to use their authority to violate constitutional rights. It has actually been on the books since Reconstruction. It was written for the express purpose of confronting lawlessness in state institutions like sheriffs, judges and jailers when they turned government power into a weapon against the people they served. That law is now codified as 18 U.S.C. Section 242. And today, it is broken. The reason is a Supreme Court decision from 1945, Screws v. United States, which rewrote the statute in a way Congress never intended. The court inserted a requirement that the government must prove a public official acted not just intentionally, but with the specific purpose of violating a right they knew to be protected under federal law. In doing so, Screws transformed Section 242 from a tool of accountability into an instrument of evasion. Since that decision, officials have escaped prosecution, not because they acted lawfully, but because prosecutors could not prove what they were thinking about federal law at the exact moment they acted. Far from clarifying the limits of state authority, Screws transformed a straightforward criminal statute into a psychological investigation, tethered not to the clarity of law, but to the ambiguity of individual understanding. This interpretation was never grounded in the statute's text. It was never rooted in its purpose, and it is plainly incompatible with the original design of civil rights enforcement in the United States. The law was built to protect people from purposeful, official misconduct, not merely when the actor recognized the exact legal doctrine they were violating, but when they used government authority to punish, suppress, or harm others in a way that ultimately denied them their federal rights. Screws was wrongly decided, and dangerously so. It did not merely misread a statute, it rewrote the behavioral and evidentiary standards for what counts as official misconduct, raising the bar so high that even outrageous intentional abuses often go unpunished. What the text once made clear, that public authority may not be wielded as an instrument of unlawful power, was replaced with a far narrower idea, that only if the abuser's legal knowledge and subjective intent can be proven in court does the statute apply. This was a mistake of legal and constitutional reasoning, and it is time to correct it. Today we lay out the case for restoring Section 242 to its original meaning. We begin by analysing how the statute was structured and how it operated before the Screws decision. We examine the three essential elements it contains: state authority, intentional action and rights deprivation, and how they defined a coherent and limited but vital form of criminal liability. We then show how Screws reshaped that logic, elevating subjective mental state over objective harm and transforming evidentiary burdens in a way Congress never intended. Finally, we explain why this shift has weakened public protections and undermined the statute's constitutional function. This is not an abstract legal concern. In cases of police brutality, unlawful detention, racial violence, or official retaliation, 18 U.S.C. Section 242 was meant to provide a direct federal remedy when state actors knowingly abuse their power. While civil recourse exists under 42 U.S.C. Section 1983, that statute serves a different purpose. It permits private lawsuits for damages. It does not authorize the federal government to speak for the public in condemnation of official abuse. Section 242 alone gives the executive branch a criminal mechanism to protect constitutional order. But under the Screws standard, that mechanism too often fails, not because there was no harm, and not because the abuse wasn't intentional, but because prosecutors cannot prove what the official believed about federal law at the moment they acted. To understand how the executive lost these critical powers, we have to turn to the history of the Act. Originally enacted as part of the Enforcement Act of 1870 during Reconstruction, what is now codified as 18 U.S.C. Section 242 was designed to confront the reality that state and local governments were actively participating in or turning a blind eye to the violation of federal rights, particularly in the southern states following the Civil War. Its purpose was not to manage ordinary crimes or misjudgments, but to create a federal mechanism for protecting individuals from abuses of state power, especially those rooted in racial and political suppression. The statute was crafted as a criminal prohibition, directed squarely at those acting under colour of law who used public authority to intentionally violate constitutional or federal rights. Unlike civil remedies, this provision imposed criminal liability, not for all failures of duty, but for those where state power was used with willful intent to deny the protections of the Constitution. From the outset, then, Section 242 served as both a deterrent and a shield. Its function was to define the boundaries of legitimate public authority by prohibiting its deliberate misuse to harm the governed. While rarely, if ever, pursued as a first remedy, it provided the federal government with the credible threat of criminal sanction for continued non-compliance. What emerged was not a comprehensive doctrine of public duty, but a pattern of prohibited conduct, from which the boundaries of protection could be inferred. This pattern gave legal substance to the promise that federal rights could not be overridden by state actors, even those formally empowered, when they acted in violation of their public trust. To understand the original protections created by Section 242, we examine its core prohibition clause as three elements, which together define the scope and structure of the safeguarded public right. The statute begins by defining who falls within its reach, those who act with the appearance of state authority, regardless of legality. Whoever, under colour of any law, statute, ordinance, regulation or custom, this clause establishes the jurisdictional foundation of Section 242. It applies to anyone who invokes government power to act, whether formally, customarily, or under mere pretense. This included public officials acting officially, persons relying on legal forms or procedures, and those claiming customary authority under state or local norms. The key concept was colour of law, the use or appearance of public power, regardless of whether it was legally correct. This ensured that the law applied to any actor functioning as the state, even if that appearance masked unlawful or informal power structures. This element thus affirmed that the public is protected from the abuse of all apparent government power, not just from actions taken through valid or regular processes. Criminal liability under Section 242 depends on more than state authority. It requires purposeful action. Willfully subjects any person in any state, territory, commonwealth, possession or district. This clause limits the statute to intentional conduct, distinguishing deliberate use of power from mere negligence or misjudgment. Here, the statute introduced its mental state requirement. The act had to be committed willfully, meaning with purpose or intent. It was not enough that a person be harmed under state authority. The actor had to intend to subject them to what followed. The term subjects connoted more than incidental exposure. It required deliberate imposition. This protected the public by criminalizing not mere error or negligence, but the intentional use of governmental power to bring harm, and specifically harm to federally protected persons, regardless of location. This ensured that the intent to use state power as a tool of suppression or injury was a prosecutable wrong, protecting individuals from targeted misuse of public force. The final clause defines the harm the statute prohibits, the denial of a federally protected right, to the deprivation of any rights, privileges or immunities secured or protected by the Constitution or laws of the United States. The final element articulated the harm, the denial of a right guaranteed by federal law. These rights were not enumerated in the statute. They were defined by the broader legal framework, the Constitution, particularly the Bill of Rights and the 14th Amendment, and federal statutes. By using the phrase secured or protected, the law encompassed both explicit constitutional guarantees and those made real through federal enforcement mechanisms. This meant the law protected individuals from being stripped of liberty, due process, equal protection, or other federal entitlements by any person acting under governmental guise. This clause linked federal criminal law to the preservation of civil rights, marking the boundary that official conduct could not legally cross. Reflections on structure and intent. The statute also included a second operative clause, which extended criminal liability to those who imposed different punishments, pains or penalties on account of such person being an alien or by reason of his colour or race. This clause explicitly targeted discriminatory enforcement and punishment, a practice widespread in the postbellum South. It criminalized unequal treatment in legal process and punishment on racial or national grounds, reflecting the specific civil rights abuses that prompted federal intervention. While not structured identically to the primary prohibition clause, this provision reinforced the same protective principle. State power may not be used to impose differentiated harms based on identity. This clause laid the groundwork for later equal protection enforcement, but was historically distinct in its focus on punitive disparities. Though Section 242 includes criminal penalties, including enhanced penalties for acts involving bodily injury, weapons, or death, these provisions were treated separately from culpability. In the original structure, the core triad established the criminal offence. The penalty followed only once guilt was established. This separation preserved the statute's focus on defining prohibited conduct first and assigning graduated punishment second, depending on the severity of the harm and the intent proven. Thus, while sentencing shaped consequences, it did not affect the elements of the crime itself. The original version of Section 242 presented a carefully balanced legal structure. It was narrow enough to avoid criminalizing error or policy disagreement, yet powerful enough to target those who deliberately turned the force of the state against individual rights. Each element of the statute served both as a jurisdictional filter and a protective barrier. The law only intervened where first, state power was being used or invoked, second, that power was applied willfully to a person, and third, the action resulted in a recognizable violation of federally guaranteed rights. What this reveals is a regime that took public protection as its first principle, not by defining what the state must do, but by defining what it may not do, and doing so in a form enforceable by criminal sanction. The law's original structure prioritized accountability over administrative complexity. Its standard was simple, its burden high, and its intent clear. It empowered the federal government not to manage all state misconduct, but to intervene where state power was used with purpose to suppress the rights of the governed. In doing so, Section 242 established not just a rule of criminal liability, but a federal promise of restraint, that no person, however official, could use the power of the state as a tool of intentional oppression. While the statute defines the conditions under which its protections apply, the evidentiary burdens required to substantiate a charge must be inferred. The statute did not frame these burdens as affirmative procedural rules, but they were logically entailed by the prohibition structure itself. In order for the government to criminally prosecute someone under Section 242, it had to negate each of the lawful conditions, that is, to prove that the action was not a valid exercise of authority, but a misuse of state power. Each element of the statute corresponds to a point of factual inquiry, and thus a burden of proof. Without demonstrating each one, no violation could be established. These were not aspirational tests. They were the minimum thresholds for criminal culpability. We now examine the statute's original operative language again, this time from the perspective of what the government was required to prove in a prosecution. To prosecute under Section 242, the government must first prove the defendant acted under state authority or its appearance. Whoever, under colour of any law, statute, ordinance, regulation or custom. Now, for the evidentiary requirement, the government had to prove that the defendant had acted under colour of law, meaning basically that the act had been carried out with the appearance or invocation of public authority, whether or not that authority had been lawfully exercised. This could include officials in uniform, using official tools or procedures, or invoking state rules or customs to justify the act. It also extended to those operating under informal or extra-legal norms that had become institutionalized, like, for example, racial customs enforced by local officials. The burden here was not to show that the act was legal, but that it was enabled by the actor's relationship to government power and not done in a purely private capacity. The prosecution had to substantiate this with evidence such as employment status, uniform or equipment, public setting, official documentation, or conduct explicitly tied to state processes. The next step is intent. The government must show that the defendant deliberately acted upon another person, willfully subjects any person in any state, territory, commonwealth, possession, or district. And the evidentiary requirement here is that the government also had to prove that the defendant acted willfully, that is, with purpose and intent to impose the resulting harm, and with a basic understanding that the action was not justified. This did not require full legal comprehension or precise knowledge of the violated right, but it did require intentional conduct directed at a person, not accident, mistake, or good faith enforcement. The prosecution had to produce evidence that the defendant had intended to engage in the act that caused harm, and that they had done so not as a reflex or judgment error, but as a deliberate use of power. Finally, Section 242 demands that the action result in a violation of a federally protected right. To the deprivation of any rights, privileges or immunities secured or protected by the Constitution or laws of the United States. Finally, the prosecution had to demonstrate that the act resulted in the actual deprivation of a specific federally protected right. This required showing that the right existed at the time of the act, and that the conduct infringed upon it in fact, not merely in appearance. It was not enough that the act was excessive or immoral. It had to violate a right clearly recognized under the Constitution or federal law. The right did not need to be formally cited by the actor, but it had to be legally identifiable, and the government had to connect the action to that deprivation. For example, an unlawful search implicating the Fourth Amendment, the use of force without due process implicating the 14th, or race-based punishment implicating the Equal Protection Clause. If the prosecution charged under the second clause of the statute discriminatory punishment on account of such person being an alien or by reason of his color or race, then it also had to prove that the difference in treatment was directly caused by racial or national origin bias. This required not only showing unequal treatment, but establishing discriminatory motive or pattern through comparative punishment, prior statements, or systemic practice. This burden was significant and separate from the general deprivation clause, making such cases especially complex even under the original statute. What this structure reveals is a statute designed with precision and restraint. It did not impose criminal liability casually, but required the government to prove first that the actor was empowered by or appearing as the state, second, that the actor intended to impose the action, and third, that the result was a real violation of a federally guaranteed right. These were not technicalities, they were the definitional boundaries of the law's reach. Each evidentiary requirement corresponded to a moral and legal threshold: the misuse of public position, the targeting of a person through deliberate act, and the suppression of a protected right. Taken together, these burdens ensured that Section 242 remained focused on true abuses of state power, not ordinary disputes or procedural failures. In its original design, the statute did not serve to manage police error, bureaucratic failure, or ambiguous legality. It existed to punish those who used the state itself as an instrument of oppression, and by requiring the government to prove each component with clarity, it preserved both the integrity of its protections and the gravity of its penalties. In Screws versus United States in 1945, the Supreme Court introduced a significant reinterpretation of the behavioral restrictions established by the original version of 18 U.S.C. Section 242. Before this decision, the statute prohibited state actors from using their official authority intentionally in a manner that resulted in harm to constitutionally protected rights. The court, however, held that conviction required proving not just intentional harm, but a specific intent to deprive someone of a federally protected right. The court emphasized that juries must find the acts were done willfully and with the specific intent to deprive a person of a right secured by the Constitution and laws of the United States. Though superficially subtle, this shift profoundly changed the nature of prohibited conduct. It redefined the behavioral limitations imposed by the statute by linking criminal liability directly to the official's subjective purpose regarding the specific right violated, not merely to the intention to perform harmful acts. Screws redefined what it means to deprive someone of a protected right as required by the clause to the deprivation of any rights, privileges or immunities secured or protected by the Constitution or laws of the United States. Prior to Screws, state actors were prohibited from intentionally performing actions that resulted in deprivation of federal rights, regardless of whether they recognized the nature of the right or explicitly intended its violation. After Screws, the prohibited conduct became narrower. The actor had to deliberately target the deprivation of a right they recognized, not simply perform an act that objectively violated the right. Thus, prohibited behavior shifted from general intentional misconduct to a specific form of misconduct. The official had to purposefully choose to violate a protected right, making mere reckless or negligent deprivations insufficient to constitute a criminal violation. Actions became unlawful under Section 242 only if conducted with the conscious purpose of denying a constitutional protection, shifting the prohibition from harmful outcomes alone to a much narrower realm of explicitly rights-targeting conduct. Although Screws did not alter the text of the statute, it changed how this clause functions in practice. Whoever under colour of any law, statute, ordinance, regulation or custom. Before Screws, conduct was prohibited simply because it involved misusing governmental authority. But after the ruling, the restriction was conceptually modified. Because the misconduct required a deliberate violation of a recognized federal right, the behavioral constraint was implicitly changed. Authority could be misused generally without necessarily violating Section 242. Now, prohibited conduct required misuse of authority in a manner explicitly intended to override a right. Practically, this altered how state actors understood their limits. The prohibition was no longer triggered simply by abusive use of official power, but only by power misused specifically to achieve a known rights violation. This new behavioral restriction subtly suggested to state actors that they might misuse their authority broadly, so long as it was not purposefully aimed at denying particular constitutional guarantees. And this changes worked to undermine the original intent provision. Willfully subjects any person in any state, territory, commonwealth, possession or district. Under the original statute, willfulness prohibited all intentional misuse of power that resulted in deprivation of rights, regardless of whether the right was specifically known or intended. After Screws, though, the prohibited conduct narrowed significantly. It required actors not merely to intend their harmful acts, but also to consciously intend the denial of constitutional rights. So, behaviourally, the statute now allowed significant room for intentional misconduct that escaped criminal liability because of ambiguity about whether the actor deliberately sought to violate a particular right. Actions that were clearly intentional but motivated by general hostility, anger, or even malice toward the victim without explicit rights-targeted intent no longer fell clearly within the statute's prohibition. Officials were effectively constrained only by a narrower prohibition, requiring them to have a specific cognitive orientation toward rights violations. The Screws ruling imposed a radical reinterpretation of prohibited conduct by shifting focus from general misuse of state authority to a specific intent to infringe federally protected rights. Before this decision, officials were restrained by prohibitions based primarily on observable, objectively harmful acts. Afterward, the behavioral restriction narrowed dramatically, moving the statute's protection away from objective accountability and towards subjective purpose. This doctrinal shift created profound consequences. It implicitly permitted significant intentional abuses of power, provided they did not include conscious targeting of constitutionally recognized rights. By redefining prohibited behavior through the lens of subjective intent to deprive rights, the court significantly narrowed the statute's behavioral constraints, fundamentally altering the original protective scope and leaving substantial space for harmful conduct not clearly directed at known rights. In short, after Screws, the statute's protection became contingent upon what officials knew and deliberately chose, rather than upon the harm their actions actually inflicted. This marked a pivotal and lasting doctrinal turn in the behavioral limits imposed on public officials by Section 242. The Supreme Court's holding in Screws v. United States, back in 1945, imposed a new evidentiary requirement that fundamentally redefined the prosecutorial burden under Section 242. It was no longer sufficient to prove that a state official had acted intentionally and that the act resulted in a deprivation of rights. Now the prosecution had to prove that the defendant specifically intended to deprive the victim of a right protected by the Constitution or laws of the United States. Although the language of the statute stayed the same, this interpretation had the practical effect of inflating the evidentiary burden for each clause, not just the one explicitly addressed by the court. What emerged was a structurally recursive burden. To prove the specific intent required in the third clause, the government increasingly had to produce corroborating evidence across all three elements, making each one less independently sufficient. So let's break down the first clause one last time. Whoever, under colour of any law, statute, ordinance, regulation or custom. Originally, this clause required only proof that the actor had been functioning in an official capacity or using the appearance of legal authority. But after Screws, this threshold became more difficult to establish convincingly because it was no longer just a standalone jurisdictional condition. It now fed into the question of whether the official had knowingly and wrongfully applied that authority to deprive a right. So prosecutors now had to produce not just evidence of official capacity, but also demonstrate that the legal authority exercised was clear enough that the actor could be presumed to know its limits. If ambiguity about legal authority existed, especially in chaotic or ambiguous situations, it could undermine the specific intent requirement tied to the right's deprivation. This led to an evidentiary inflation. Official status had to be shown not merely by documents or rolls. Moving to the second clause, willfully subjects any person in any state, territory, commonwealth, possession or district. While Screws formally claimed not to redefine willfully, it actually raised the bar by tying it to knowledge of specific legal rights. Before, it was enough to show that the defendant acted intentionally or with reckless disregard. But after the ruling, prosecutors had to show that the act was not only deliberate, but done with an additional layer of mental awareness. The actor must have known, or at least strongly suspected, that what they were doing would violate a specific federally protected right. This made circumstantial and contextual evidence, like training, policy warnings, or prior legal exposure, way more central to establishing intent. Witness testimony, documentation of warnings, or patterns of conduct became necessary not just to show the act was done knowingly, but that it was done with legal awareness of its wrongfulness. Willfulness then shifted from an inference drawn from conduct to a construct built from surrounding facts, requiring prosecutors to reconstruct the mental environment of the defendant in detail. The evidentiary burden became heaviest where the statute's protective core was meant to reside. To the deprivation of any rights, privileges or immunities secured or protected by the Constitution or laws of the United States. It is no longer enough to prove that a right was denied. The prosecution must reconstruct the defendant's understanding of the right and prove they meant to override it at the moment they acted. Here, the transformation was most direct and severe. Before the Screws decision, it was enough to show that a constitutionally protected right had been violated as a result of the official's intentional conduct. But after Screws, the government had to show not only that the right was violated, but that the actor recognized it as such at the time of the act. This placed the prosecution in a double bind. Now it had to prove that the right was clearly defined in law, and that the defendant had personally understood their conduct to be infringing on that right. In practical terms, this burden became just about insurmountable in cases involving newly emerging interpretations of rights, or situations where the official could plausibly claim ignorance of constitutional limits. As a result, prosecutors were forced to introduce materials that had previously been irrelevant: prior court rulings, departmental training manuals, policy memos, or statements from the defendant showing their familiarity with the relevant right. Only by reconstructing the actor's access to or exposure to such knowledge could the government sustain the specific intent to deprive theory. A compounding evidentiary structure is what emerged after the Screws decision. The ruling transformed Section 242 from a statute focused on intentional abuse of power resulting in rights violations into a statute that punished only those abuses committed with specific, legally informed intent to deprive a known right. While the court framed this as just a narrow interpretive refinement, it actually fundamentally altered the government's burden in prosecuting civil rights violations. Each clause of the statute, originally capable of being proven through direct or circumstantial fact, became interdependent and interpretively fragile. To prove a violation of one, the government had to retroactively substantiate the defendant's legal understanding of the entire structure. This evidentiary inflation made Section 242 prosecutions rare, legally complex, and increasingly dependent on objective records of subjective mental states. In this way, the changes directly triggered a triadic evidentiary escalation, a feedback loop where each element's burden grew in response to the elevation of the last. It was no longer enough to prove what was done and what was lost. The government now had to prove what the actor believed, knew, and intended in legal terms at the moment the act occurred. 18 U.S.C. Section 242 was never designed as a personal right of action. It was not written for private citizens to bring in their own name, nor does it authorize freewheeling or retaliatory enforcement. It was written for one purpose: to give the federal government the legal authority to intervene when state and local governments turn the force of law into an instrument of oppression. The Screws Court did not purport to rewrite the statute gratuitously. Its stated concern was the due process clause, that the statute might be too vague to support criminal penalties without violating constitutional notice requirements. But instead of addressing this concern directly through a clear limiting construction or acknowledging a need for legislative revision, the court chose a subtler and more corrosive route. It introduced a new mental element into the statute, requiring the government to prove that the official specifically understood they were violating a protected right at the time of the act. This solution did not resolve the vagueness problem. It displaced it. By shifting the burden onto prosecutors to reconstruct an official's subjective legal understanding at the moment of misconduct, the court effectively traded a concern about unclear statutes for a regime of unclear accountability. It subordinated public protection to speculative inquiries into state of mind, and in doing so, collapsed the statute's outer boundary into the variable psychology of each defendant. The result was not clearer law, but a standard that is both less predictable and less enforceable, insulating unlawful power from review precisely when it is most dangerous, when wielded under official guise, in violation of known constitutional norms, but without a provable cognitive acknowledgement of that fact. It is, and has always been, a structural statute. Its function is executive, not remedial. It exists so that when public officials, especially in jurisdictions that refuse to police their own, willfully misuse their authority to deny constitutional rights, the federal government may act. It was meant to be wielded with restraint, but also with clarity, as a line in the law that state actors may not cross without consequence, not to litigate policy, not to micromanage local government, but to preserve the constitutional order from its most direct threat, lawless power cloaked in legality. The decision in Screws misunderstood this entirely. By reading a requirement of subjective legal awareness into the statute, the court did not simply protect bad actors from overzealous prosecution, it insulated them from accountability altogether. And more than that, it weakened the executive branch itself. The Department of Justice cannot use this statute effectively, not to coerce, not to threaten, not even to demand reform, unless it can plausibly invoke prosecution. And that requires a workable legal standard. The vast majority of Section 242 cases do not end in trial. They end in consent decrees, plea agreements, or internal disciplinary reform initiated under federal pressure. But without the credible power to prosecute, even that quiet federal supervision collapses. Screws didn't just make conviction harder. It disabled the sword Congress gave the executive. It turned a tool of accountability into an empty threat. That was never the intent. The Reconstruction Congress understood, as we must again, that federal rights are not self-enforcing and that state power can become its own enemy. They gave the federal government a criminal statute to intervene when it must, not to manage all misconduct, but to punish the kind that subverts the constitutional compact. In that light, Screws is not just a doctrinal mistake, it is a constitutional failure. It invites impunity where federal law promised restraint. This is not a call to invent new rights, it is a call to enforce existing ones. The Constitution forbids the willful deprivation of liberty without due process, of equal protection under law, of the right to be free from excessive force. When those deprivations are carried out under the guise of government authority, the public has no remedy, except the one Congress already gave us. We urge the court to see Screws for what it is, a misstep that has distorted civil rights enforcement for nearly 80 years. It can and should be corrected, because on this issue, textual fidelity, constitutional structure and individual liberty all point the same direction. Reflect on the stare decisis factors from Dobbs, Janus and Kimball. Screws was egregiously wrong. It has created unworkable standards. No significant reliance interests justify its retention. The statute's meaning is sufficiently clear from text and history to support correction. The conclusion is inescapable. Overrule Screws. Restore Section 242. Reaffirm that in the United States no official stands above the Constitution, not even in uniform, not even under color of law.